The footage is grainy, pulled from a fixed security camera mounted above the defendant's table in Courtroom 4 of the Essex County Superior Court. It is November 2019. The boy in the frame is 14 years old. His name is Caleb Morrow. His mother, Karen Morrow, 41, a licensed practical nurse who volunteered every Sunday at her church's food pantry, had been dead for 11 days. The cause of death, blunt force trauma to the skull, delivered 6 times with a steel baseball bat. The weapon was found wiped clean, leaning against the garage wall as though it had never moved. The boy who put it there is the boy now sitting in that courtroom, adjusting his collar, scanning the ceiling with the glazed expression of someone waiting for a bus. The prosecutor, Assistant District Attorney Miriam Cole, reads aloud the first forensic finding: blood spatter consistent with high-velocity impact found on the defendant's right sleeve. In that moment, captured clearly on the security footage that would later be shown to millions, Caleb Morrow turns to his court-appointed attorney, leans close and smiles. Not the nervous twitch of a frightened teenager. A slow, deliberate smirk. The kind that says, "I know something you don't." The courtroom noticed. The judge noticed. The nation would notice. But what Caleb did not know, could not have imagined, was what would happen next. Because buried inside the prosecution's evidence files, beneath the forensic reports and the neighbor's testimony and the cell phone records, was a piece of information so damning, so precise, and so irrefutable, that when the judge finally revealed its implications during sentencing, even the defense attorney went pale. The smirk would not survive the week. And the judge, a woman known for measured calm, would make a decision that rewrote legal history for juvenile offenders in the state. What the security camera did not show, but what investigators had already confirmed, was that Caleb's phone had connected to a Wi-Fi network 17 blocks from his home at 11:47 p.m. on the night of the murder. That network belonged to a gas station. The gas station had its own camera. And that camera had captured everything. Stories like this remind us that justice always finds its way. Every smirk, every denial, every carefully wiped surface eventually meets the one detail that survived. If you believe in accountability, subscribe now and share your thoughts below. Because this story is only beginning. But before the courtroom, before the forensics, before the footage, there was a woman named Karen Morrow, who woke up every morning at 5:15 a.m. to pack lunches for a son she loved without condition. Understanding what was lost requires understanding who she was. And understanding who she was makes what happened next almost impossible to process. The gavel had not yet fallen. The smirk was still on the boy's face. And somewhere in the evidence room, a gas station surveillance file sat in a manila envelope, waiting. Karen Morrow grew up in Maplewood, New Jersey, the second of 3 children in a household where money was always tight but warmth was never rationed. Her mother, Gloria, worked 2 jobs. Her father, Bernard, drove a city bus for 30 years. Karen inherited from them a particular kind of stubbornness, the kind that doesn't quit, that fills out college applications by flashlight, that shows up to nursing clinicals after a double shift at the diner. By 32 she had her LPN certification, a rented townhouse on Fenwick Lane, and a son who drew pictures of dinosaurs on the backs of her grocery lists. Fenwick Lane was the kind of quiet street where neighbors still knew each other by name. Eleanor Vance, who lived directly across from Karen, would later tell investigators that she watched Karen plant yellow tulips along the front walk every April, and that on the morning after the murder, those tulips were still standing, unbothered, which made the whole thing feel like a mistake. Like the world hadn't caught up yet. Like it was still the kind of street where nothing like this could happen. Karen raised Caleb alone after his father, Marcus, left when Caleb was 3. There was no dramatic exit. Marcus simply stopped returning calls, then stopped existing in any practical sense in their lives. Karen never spoke badly of him, at least not in front of Caleb. Neighbors recalled that she was patient in a way that seemed almost deliberate, measured, like someone who had made a conscious decision to choose softness over bitterness. She attended every school conference. She drove Caleb to baseball practice twice a week even when she worked overnight. She left notes in his lunch. She worried openly to her closest friend Diane that she was too soft with him. Around the time Caleb turned 12, something changed. Karen mentioned it in text messages to Diane that were later obtained by investigators. She wrote that Caleb had become cold, that he looked at her sometimes like she was a stranger, that he had begun to lie, small lies at first, then larger ones that required construction, architecture, collaboration with invented versions of events. A teacher at his school filed a behavioral note after Caleb was found photographing another student's home address during a class trip. When Karen confronted him, he stared at her without expression for a long moment, then said, I was just curious. She texted Diane that night, "Something is wrong with my son and I don't know how to fix it." On October 29, 2019, 8 days before her death, Karen Morrow worked a 12-hour shift, stopped at the grocery store, made spaghetti for dinner, and watched half a movie with Caleb before he said he was tired and went upstairs. She told Diane afterward that it had been a good evening, that he had laughed at a joke she made, that she thought maybe things were turning around. She fell asleep on the couch with the television on. Caleb was still awake upstairs. Investigators would later confirm, through his search history, what he was doing on his phone at that hour. At trial, Diane Castillo took the witness stand and described her best friend in 3 sentences that reduced 4 jurors to visible tears. She was the kind of person who apologized when you bumped into her. She called her mother every Sunday without fail. And she loved that boy in a way that had no logic to it. She just loved him completely, even when he scared her. Diane paused. Then she added, "She told me once that she would do anything to protect him. I don't think she ever imagined that she needed protecting from him." Karen Morrow had planted tulips that spring with the quiet confidence of someone who expected to see them bloom again the following year. She would not. But the women who loved her would make sure she was never reduced to a case number. And across town, in a juvenile detention facility, the boy who had taken her from them was, at that very moment, filing a request to be moved to a cell with a window. At 9:42 p.m. on November 6, 2019, Caleb Morrow sent a text message to a classmate named Darius Webb. The message read, "Tonight. Nothing else." Darius, who would later testify that he had no idea what the message meant at the time, replied with a question mark. Caleb did not respond. At 10:15 p.m., all activity on Caleb's phone ceased, which investigators would later identify as the point at which he placed the phone face down on his desk, according to accelerometer data, and did not pick it up again for 93 minutes. The Morrow townhouse on Fenwick Lane had a specific layout: kitchen and living room on the ground floor, 2 bedrooms and a bathroom on the second. Karen's bedroom was at the end of the hall. Caleb's room was adjacent to the staircase. When Karen fell asleep, confirmed by her smartwatch which logged a drop in movement at 10:08 p.m., she was on the living room couch, a fleece blanket pulled across her legs. She was still wearing her scrubs. The television was tuned to a cooking competition. The volume was set to 14. These details were established because the television was still running when the neighbor, Eleanor Vance, arrived at 6:50 a.m. the next morning to return a borrowed casserole dish. The medical examiner's report, presented at trial, established that Karen Morrow suffered 6 blows to the posterior cranium. The first blow rendered her unconscious. The remaining 5 were delivered with escalating force over a period of approximately 90 seconds. There was no evidence of struggle, no defensive wounds on her hands or forearms. The medical examiner testified that she was almost certainly unaware of what was happening. She did not fight back. She could not. The steel bat, a 32-inch Louisville Slugger that Karen had purchased for Caleb's baseball season 2 years earlier, was recovered 11 feet from the body. What investigators found astonishing, and what the prosecution would later use to argue premeditation, was the evidence of deliberate cleanup. The bat had been wiped down with a solution consistent with diluted bleach. Caleb had showered. The clothes he had been wearing were placed in a plastic bag tied shut and pushed beneath a loose board at the base of his closet, a discovery made only because Detective Angela Hurst noticed the floorboard was newer than the others. Inside the bag, a gray hoodie, sweatpants and a pair of white socks. All saturated. At 11:47 p.m., Caleb Morrow left the house. The reason, still never fully explained, has been theorized by investigators as either an attempt to establish an alibi or a moment of panic. He walked 17 blocks to a BP station on the corner of Granger and Mill. His phone connected to the station's open Wi-Fi. The station's exterior camera captured him clearly, hoodie pulled up, moving at a moderate pace, hands in pockets. He stood at the edge of the parking lot for 4 minutes and 30 seconds. Then he walked home. He would tell investigators he had been asleep all night. Eleanor Vance knocked at 6:50 a.m. When there was no answer, she peered through the sidelight window and saw the television, the blanket, Karen's feet, and then understood that something was wrong. She called 911 at 6:53 a.m. When officers arrived at 7:02 a.m., they found Karen Morrow on the living room floor. She had been moved, slightly awkwardly, from the couch. Caleb was upstairs in bed, still in clean pajamas, performing sleep. The bat leaned against the garage wall. The television still murmured. The tulips outside stood straight in the November cold. And upstairs, a 14-year-old boy lay on his back in the dark, eyes open, listening to the sound of sirens getting closer. Angela Hurst had been with the Essex County Major Crimes Unit for 11 years. She was not a dramatic person. Colleagues described her as methodical, almost uncomfortably patient. She once spent 6 hours in a suspect's driveway without moving because she had a feeling. The feeling had been right. She arrived at 37 Fenwick Lane at 7:18 a.m., 16 minutes after the first officers. She stood at the doorway for 2 full minutes before entering, taking in the scene with the stillness of someone reading a very long sentence. The living room told a story of interrupted rest. The blanket, the remote control at the edge of the couch cushion, a glass of water on the end table. What it did not tell was a story of break-in, of chaos, of confrontation. There was no ransacked drawers, no forced entry, no signs of a fight. Hurst would write in her notes that it felt domestic in a way that was immediately unsettling. This didn't happen to her, she wrote. It happened around her. Like whoever did this lived here. At 7:31 a.m. uniformed officers brought Caleb downstairs. He was wearing clean pajamas and carrying a phone charger for reasons no one asked about at the time. He was told his mother had been hurt. His response, captured in body camera footage that would become central to the trial, was a measured, almost studied expression of confusion. He said what? Once. Then he sat at the kitchen table and asked if he could have cereal. Detective Hurst, watching from the doorway, made a note. Caleb was taken to the station as a witness, not a suspect, initially. He sat across from Detective Hurst for 47 minutes. He was calm, cooperative, and largely consistent. He said he had been in his room since 9 p.m. He said he hadn't heard anything. He said he loved his mother. He said all of this without crying, without trembling, without the physiological signatures of a child who has just lost a parent in a violent and sudden way. Hurst later testified, he talked about his mother in the past tense 3 times before we told him she was dead. The decision to examine Caleb's phone came within the first 4 hours, not because he was suspected, but because it was protocol. What the digital forensics team found in the first pass was the text to Darius Webb. What they found in the second pass was the Wi-Fi connection log. What they found in the third pass, after obtaining a warrant that same evening, was a browser search conducted at 10:19 p.m. the night before. How long does it take for blood to dry on wood floors? Detective Hurst returned to the house at 4:15 p.m. with a forensic team. She moved through Caleb's room slowly, methodically. It was the floorboard near the closet, a single plank, slightly lighter in color than the surrounding wood, with newer screw heads, that made her stop. She knelt. She pressed it. Gave. The plastic bag beneath it held everything the prosecution needed. By 6 p.m. on November 7, 2019, less than 24 hours after Karen Morrow's death, a warrant had been signed for Caleb Morrow's arrest. Detective Hurst sat in her car in the station parking lot for a long moment before going back inside. She had worked murders for 11 years. This one, she would say later, was the one she couldn't stop thinking about at 3 a.m. Not because of the brutality, because of the serial. The full forensic analysis of Caleb Morrow's phone and laptop took 9 days and produced a document that was, by the time it reached court, 83 pages long. What it revealed was not impulsive but architectural. Over a period of 6 weeks preceding his mother's death, Caleb had searched, across multiple browsers and attempted incognito sessions, the following terms: how to clean blood off wood, does bleach destroy DNA on fabric, juvenile tried as adult, New Jersey age requirements, what happens if minor kills parent, and, chillingly, can smartwatch track sleep when dead. He had also visited 3 forums related to forensic investigation, not out of curiosity but, as later analysis of his reading patterns suggested, to understand what investigators look for. The prosecution's challenge was motive. Caleb had not been overtly abused. He had not been in imminent danger. Financial gain was irrelevant. Karen had no life insurance beyond a small work policy, and Caleb, at 14, had no mechanism to access it. What emerged from the psychological evaluation and from the witness accounts of teachers and peers was a picture of something else. A boy who had decided, in some cold and private calculus, that his mother was an obstacle. An obstacle to what, exactly, was never fully resolved. But the most consistent theory, supported by his therapist's notes from the previous year, was control. Karen had recently begun enforcing boundaries. She had taken his phone at night. She had grounded him for a month after a school incident. She had told Diane she was trying to be firmer. Darius Webb testified that Caleb had spoken to him, 3 weeks before the murder, about wanting to start over. Darius had assumed it meant changing schools. Caleb had said specifically, "I just need her to stop being in my way." When Darius asked what he meant, Caleb had smiled, the same slow smile later captured by the courtroom camera, and said, "Nothing. Forget it." Darius had forgotten it. Until he received the text on the night of November 6th. Until the police came to his door 2 days later. He testified that he had cried in the parking lot of the police station for 15 minutes before going inside. The BP station on Granger and Mill handed over 48 hours of footage without resistance. Forensic technician Marcus Bell identified Caleb from the footage in under 2 hours. The build, the gait, the specific hoodie, which matched fiber evidence recovered from the scene, were unmistakable. What the footage also captured, from a different angle than the exterior camera, was the reflection in the gas station window. In that reflection, for a fraction of a second, the hood slipped. His face was visible. Clear. Come. Eleanor Vance had not initially mentioned something during her first interview. She was embarrassed by it, she said. She told Detective Hurst during a follow-up 3 days later. At approximately 11:30 p.m. on the night of November 6th, she had been awake with insomnia and had glanced out her bedroom window. She had seen a figure leave the Morrow house. She had assumed it was Karen leaving for a late shift. She had not thought about it again until she was sitting in Detective Hurst's office and the timeline clicked. Her statement placed the departure time 19 minutes before the Wi-Fi connection log. The math matched exactly. On November 8, 2019 at 8:22 a.m., Caleb Morrow was arrested at the juvenile detention facility where he had been held pending evaluation. He was informed of the specific charges, first-degree murder with premeditation, by Detective Hurst and a juvenile liaison officer. According to the liaison officer's report, Caleb received the information, looked at Detective Hurst steadily for a moment and said, "That's a lot of work for nothing." He then asked when he would get his phone back. The evidence file grew heavier each day. The 83 pages of digital forensics. The fiber report. The medical examiner's findings. The neighbor's statement. The gas station footage. The plastic bag with the saturated clothes. Each piece a link in a chain that Caleb Morrow had believed, with the overconfidence of someone who had researched everything except for his own blind spots, he had severed. He had not. The chain held. The court appointed Dr. Patricia Shen, a forensic child psychologist with 22 years of experience evaluating juvenile offenders, to conduct a comprehensive psychological assessment of Caleb Morrow. The evaluation took place over 14 sessions across 6 weeks, producing a final report of 41 pages that the judge would later call, "the most disturbing document I have read in 30 years on the bench." Dr. Shen's findings were clinical in language but devastating in implication. Dr. Shen's assessment identified in Caleb a constellation of traits consistent with what the DSM-5 classifies as emerging antisocial personality features with significant callous unemotional (CU) traits, a diagnostic designation that, in the clinical literature, is associated with reduced capacity for empathy, impaired guilt response, and a tendency to view interpersonal relationships primarily in terms of utility. In plain terms, Caleb did not experience other people, including his mother, as fully real in the way that most people experience others. They were, in his internal framework, variables, problems to be solved or removed. The warning signs, Dr. Shen noted, had been present from early childhood but were not recognized as clinically significant at the time. At age 7, Caleb had deliberately drowned a neighbor's cat and reported it as an accident without detectable anxiety. At 9, he had fabricated a detailed account of being bullied, complete with names, dates, and physical descriptions, entirely from imagination, with such conviction that the school investigated for 3 months before discovering the whole story was invented. At 11, he had manipulated a classmate into taking the blame for vandalism Caleb had committed by planting evidence in the classmate's locker and coaching a witness. Dr. Shen described Karen Morrow's role in Caleb's life as the principal constraint. Karen had been, until approximately age 12, successfully managed by Caleb, meaning he had found reliable methods of obtaining what he wanted from her through manipulation. When Karen began enforcing stricter boundaries, this represented a failure of his established system. Dr. Shen testified, "In his framework, the logical response to a malfunctioning system is not to adapt, it is to remove the malfunction." She paused for several seconds after saying this, as though the words needed air. Throughout all 14 sessions with Dr. Shen, and through the entirety of the legal proceedings, Caleb Morrow displayed no clinically detectable remorse. He discussed his mother's death with the same emotional register one might use to describe a minor scheduling inconvenience. In one session he told Dr. Shin that he felt the biggest problem with the whole situation was that the cleanup should have been better. He said this without irony. When Dr. Shin asked if he felt sad, he considered the question for a moment and said, "I don't think that's the most useful thing to feel right now." The central legal and moral question posed by Dr. Shin's report was one that would dominate the pretrial proceedings. Could a 14-year-old, even one with Caleb's profile, be held to the same standard of culpability as an adult? Her answer was deliberately measured. She noted that Caleb's planning behavior, his research, his cleanup, and his performance during interrogation all demonstrated sophisticated executive function and the capacity for long-term consequence modeling. He understood what he was doing. He understood it was wrong. He simply didn't care. Dr. Shin's report sat in a pile on Judge Catherine Mercer's desk for 3 days before the judge read it. When she finished, she reportedly set it aside, walked to her window, and stood looking at the courthouse parking lot for a long time. What she decided in that window, what she began planning in response to what she had read, would not become clear until the sentencing hearing. But it was forming. Quietly. With the precision of someone who had been given an impossible problem and intended to solve it without apology. The question of whether to try Caleb Morrow as an adult became one of the most contested preliminary battles in the case. Prosecutor Ada Miriam Cole filed a motion to waive juvenile jurisdiction within 2 weeks of the arrest, arguing that the premeditation demonstrated by Caleb's behavior, 6 weeks of research, deliberate planning, calculated cleanup, placed the crime firmly outside the rehabilitative framework that juvenile court was designed to address. The defense, led by attorney Gerald Finch, argued with equal force that a 14-year-old brain, even one with Caleb's profile, was neurologically incapable of the full moral weight that adult prosecution assumed. The neuroscience portion of the hearing occupied 3 full days. The defense brought Dr. Anton Reyes, a developmental neuroscientist from Columbia, who testified about the prefrontal cortex, the brain region governing impulse control, consequence projection and moral reasoning, and its incomplete development in adolescence. He presented imaging data. He cited the Supreme Court's precedent in Roper v. Simmons, Miller v. Alabama, and related cases in which the court had repeatedly affirmed that youth is constitutionally relevant to culpability. The prosecution countered with their own expert, who argued that Caleb's planning behavior was precisely the kind of evidence that distinguished him from the impulsive adolescent the science was designed to protect. During the waiver hearing, Caleb sat at the defense table in a shirt and tie that Gerald Finch's office had provided. He watched the scientific testimony with apparent interest. The interest, several observers noted, of someone attending an informative lecture rather than a proceeding that would determine the shape of his life. At one point, while Dr. Reyes described the limitations of the adolescent prefrontal cortex, Caleb was observed writing something on a legal pad. When an officer later glanced at the pad, it said, "He's wrong about the timeline. The research shows full maturation at 25. He had corrected the expert citation. Judge Catherine Mercer had been on the bench for 17 years. She had presided over 4 juvenile transfer hearings. She had never granted a transfer lightly. She listened to 4 days of testimony in the waiver hearing with the same unreadable composure that would become her signature throughout the trial. At the end of arguments, she took 17 days to deliberate. When she returned with her ruling, the courtroom was packed. She granted the transfer. Caleb Morrow would be tried as an adult. But she added something, a single line in the written order, that no one fully understood yet. The outcome of this proceeding, if resulting in conviction, shall be subject to a sentencing framework not yet invoked in this jurisdiction. The defense immediately filed for reconsideration. Juvenile advocacy groups held press conferences. Legal commentators debated whether a sentencing framework not yet invoked was a threat, a promise, or an anomaly. Karen Morrow's mother, Gloria, who had sat in the back of the courtroom through all 4 days of the hearing, told a reporter afterward, "I don't care what they call it. I care that he's not out in 3 years." Her voice was steady. Her hands were not. When Gerald Finch informed Caleb of the judge's ruling, that he would be tried as an adult, Caleb was silent for a long moment. Then he asked, "What does that mean for the sentence cap?" When Finch explained the implications, Caleb nodded slowly. According to Finch's own account, given in an interview years later, the boy then said, "She's smarter than I thought." He said it with something that might have been, in a different person, respect. The transfer was granted. The trial date was set. And the single cryptic line in Judge Mercer's order, "A sentencing framework not yet invoked in this jurisdiction," hung in the legal air like a question that only she knew the answer to. The courtroom would wait. The family would wait. The nation, increasingly following the case, would wait. But Caleb Morrow did not wait. He requested a new notebook and began taking notes. Courtroom 4 of the Essex County Superior Court was not built for spectacle, but spectacle found it anyway. By the time jury selection began in March 2020, delayed twice for procedural challenges, the case had attracted national media coverage. The benches in the public gallery were filled every morning. Legal commentators broadcast from the steps outside. Inside, the room had the particular stillness of a place where everything has been carefully arranged to produce justice in a controlled space. Wooden benches worn smooth by decades of waiting, fluorescent lights that flattened every face equally, a gallery clock that ticked with mechanical indifference. ADA Miriam Cole stood before the jury for 47 minutes on opening day. She was not theatrical. She was architectural. She built the case piece by piece. The timeline, the research, the text to Darius, the cleanup, the gas station walk, the phone data, the floorboard, until by the end of her opening statement, the shape of what had happened was so clear and so terrible that two jurors were visibly struggling to maintain neutral expressions. She ended with Karen Morrow. Not the victim but the person. She said, "She packed his lunch the morning before she died. That's the last thing I want you to remember when you look at the defendant." Gerald Finch was experienced and competent, and he had a nearly impossible task. He could not dispute the forensic evidence, it was overwhelming. What he could do was contextualize. His opening focused on adolescent neuroscience, on the developmental framework, on the argument that the person who committed this act was not the fixed, completed human being that the prosecution was presenting. He used the word brain 22 times. He used the word monster once, negatively, as in, the prosecution wants you to see a monster. What you will see when you look at the evidence with clarity is a child in crisis. Several jury members glanced at Caleb when Finch said this. What those jury members saw when they looked at Caleb Morrow was a 15-year-old boy. He had turned 15 during the pretrial period, sitting with his hands folded on the defense table, watching Gerald Finch with polite, patient attention. He was not the wide-eyed child one might expect. He was composed in the way that still water is composed, with a depth that was difficult to read and slightly unnerving to look at too long. When he noticed jurors looking at him, he did not look away. He met their gaze, steadily, without anxiety. Several jurors would later report that this was one of the most unsettling things about the trial. Detective Angela Hurst was the prosecution's first witness. She took the stand on the second day of trial and walked the jury through the investigation with the methodical clarity of someone who had told this story a dozen times and intended to tell it exactly right. She described the scene, the serial request, the past tense references, the phone data, the floorboard, the plastic bag. She spoke for 2.5 hours across 2 sessions. Under cross-examination by Gerald Finch, she acknowledged that Caleb had been cooperative throughout the initial interview. She was then asked whether cooperative behavior indicated innocence. She looked at Finch for a moment and said, "In my experience, Mr. Finch, it can also indicate practice." It was during Detective Hurst's testimony, specifically during the reading of the blood spatter report, that the security camera caught what would become the defining image of the trial. The prosecutor read aloud the conclusion. Blood spatter consistent with high-velocity impact found on the defendant's right sleeve. In that moment, Caleb leaned toward Gerald Finch and smiled. The slow, deliberate expression that had been visible to everyone in the courtroom. The camera caught it. By that evening, the still image had been shared hundreds of thousands of times online. The public response was a single, unified, burning rage. The trial had been open for 2 days. The smirk had already become a symbol of arrogance, of absence, of everything that felt wrong about the boy at the defense table. But ADA Cole, reviewing her evidence files that evening in her office, was not thinking about the smirk. She was thinking about the next piece of evidence. The one that even Caleb didn't know she had. And across the hall, in her chambers, Judge Catherine Mercer was reviewing a legal brief she had quietly commissioned 3 months earlier, the one outlining a sentencing option no judge in New Jersey had ever used. Marcus Bell, digital forensic specialist, took the stand on day 4 of trial. He walked the jury through the phone data with a precision that made the abstract concrete. He displayed the search history on a screen that could be seen from every seat in the gallery. He read each search term aloud. How long does it take for blood to dry on wood floors? The courtroom was absolutely silent. Does bleach destroy DNA on fabric? Someone in the gallery made a sound, not quite a word but not quite not one. Can smartwatch track sleep when dead? A juror closed her eyes briefly. Marcus Bell read all 47 searches aloud without editorial comment. He did not need to editorialize. The searches did it themselves. Dr. Rita Vasquez, the county medical examiner, testified on day 5. She had a measured, respectful delivery that never sensationalized but never softened either. She described Karen Morrow's injuries in clinical language: posterior cranial trauma, impact force consistent with a 32-inch steel bat swung by an individual of Caleb's height and strength, minimum 6 contact events. She testified that the first blow had been sufficient to cause unconsciousness and that the remaining 5 had been delivered to a person who could not feel them, but that they had been delivered anyway. She paused after saying this. The room was very still. She then said, "She did not suffer." It was clearly meant as a mercy. Several of Karen's relatives were not comforted by it. Diane Castillo took the stand on day 6 and was perhaps the most devastating witness of the entire trial, not for what she knew but for what she was. She was Karen Morrow's friend of 14 years. She had a photograph in her wallet. She mentioned that she had not been able to move because moving it felt wrong. She testified about the texts Karen had sent, about the Sunday phone calls, about the Tuesday in September when Karen had called her crying because Caleb had looked at her and said, "Sometimes I imagine what my life would be like without you in it," and the way Karen had described it, not as a threat exactly, just as something so cold, so strange that she had shivered telling it. The defense objected to this testimony as prejudicial. Judge Mercer allowed it. On day 7, the prosecution played the gas station footage for the jury. It ran for 6 minutes. The courtroom watched Caleb Morrow, clear, identifiable, unhurried, stand at the edge of the BP station parking lot in the 40 minutes after his mother's death. He did not look panicked. He did not look like someone who had just experienced something devastating or terrifying. He stood there with his hands in his pockets and the city quiet around him, and then he walked back the way he had come. One juror, according to post-trial interviews, described this footage as, "the moment I understood." She did not elaborate on what she understood. She didn't need to. Ada Cole used the "tonight" text as a centerpiece of her premeditation argument. She displayed it on the screen alongside the timeline. Text sent at 9:42 p.m., phone activity ceasing at 10:15, movement detected again at 11:30, Wi-Fi connection at 11:47. She argued that the text was not meaningless, it was a marker. A timestamp. The kind of thing someone sends when a plan has passed its point of no return. She told the jury, "He told someone it was happening. He just used a word that let him claim he meant nothing by it if anyone ever asked." Caleb, throughout this presentation, looked at the screen with mild interest. The physical evidence, the plastic bag, the clothing, the bleach-wiped bat, was presented on day 8. Each item was introduced with its forensic chain of custody, its laboratory analysis, its narrative function. The gray hoodie was identified by fiber analysis as the source of the fibers found in the living room near Karen's body. The socks were identified by shoe size and manufacturer as matching the footwear impression in the blood near the couch. The bat was identified by registration. It had been purchased by Karen Morrow from a sporting goods store in 2017, with a credit card in her name, for a son who would use it to kill her 2 years later. By the end of day 8, the prosecution had constructed a structure of evidence so complete, so interlocking, so absent of gaps, that the defense had mounted only procedural challenges, none substantive, none successful. Caleb Morrow sat through all of it with the patience of someone who had expected this, had planned for it, had perhaps even anticipated enjoying it in some way that remained private. And then came day 9. And the piece of evidence that no one, including Caleb, had known existed. In the weeks following Caleb's arrest, Karen Morrow's sister Yvonne had been given access to the family home to retrieve personal belongings. While going through Karen's bedroom, a task she described as one of the most painful experiences of her life, Yvonne found in the back of Karen's closet, behind a box of Christmas ornaments, a small spiral notebook with a floral cover. Karen had been keeping a private journal. Yvonne turned it over to Detective Hurst without reading it. Detective Hurst read it. Then she read it again. Then she called Ada Cole. The journal, covering a period of approximately 8 months before Karen's death, documented in Karen's own careful handwriting a record of Caleb's behavior that she had been too frightened, too uncertain, or too hopeful to report to anyone. She had written about the cat incident. She had discovered the truth about it and confronted Caleb, who had responded by staring at her without speaking for 4 minutes. She had written about coming home one afternoon and finding her bedroom had been searched, thoroughly and carefully, as though someone was looking for something specific. She had written in an entry dated 3 weeks before her death, "I think he is planning something. I don't know what. I'm going to call the school tomorrow. There was no entry the following day. Or the day after. The next entry was 4 days later, and it discussed something routine as though the fear had retreated. Then there was no more journal. The most devastating entry, read aloud by Ada Cole on day 9, her voice steady with what observers described as controlled fury, was dated October 30, 2019, 1 week before Karen's death. It read in part, "He came into my room last night and stood by my bed. I pretended to be asleep. I don't know how long he stood there. I was too afraid to open my eyes. When I heard him leave, I got up and put a chair against the door. I sat there until morning. I don't know who to call. I don't know who would believe me. He's my son." The courtroom produced a sound that is difficult to describe, not a gasp, not a cry, but something between them. Something collective and involuntary. For the first time in the trial, something shifted in Caleb Morrow's demeanor. It was not remorse. It was not guilt. It was the expression of someone who has discovered a variable they failed to account for. He leaned to Gerald Finch and spoke briefly. Finch requested a recess. The recess was granted. During the recess, 3 journalists in the gallery quietly updated their stories. The headline most of them settled on was a version of the same sentence. She knew. Yvonne Morrow took the stand on day 10. She described finding the journal. She described handing it to Detective Hurst. She described what it had felt like to know, in that moment, that her sister had been afraid, had written it down, had not told anyone. Her testimony was not long. She was asked, at the end of cross-examination by Gerald Finch, whether she believed Caleb was capable of change. She looked at the defense table for a long moment. Then she said, "My sister believed he was. She loved him her whole life believing he was. And she is dead because she was wrong." Post-trial juror interviews painted a consistent picture. Before the journal, 2 jurors had been genuinely uncertain. Both cited the neuroscience testimony as raising legitimate doubt about full culpability. After the journal, after hearing Karen's voice in her own words, documenting her own terror in the weeks before her death, both jurors described the uncertainty as resolved. One said, "She wrote that she was afraid to open her eyes because she was afraid of her own son. That's when I knew everything I needed to know." The journal was admitted into evidence as Prosecution Exhibit 31. It was a spiral notebook with a floral cover and 61 pages of handwritten entries. The last entry was October 30, 2019. Karen Morrow had been alive for 7 more days after writing it. In those 7 days she had continued to go to work, to make dinner, to plant tulips, continuing to be his mother, right up until the moment she couldn't anymore. The journal sat in its evidence bag under the fluorescent lights of Courtroom 4, and the floral cover looked incongruously cheerful, like a wound dressed in something bright. Gerald Finch had not had an easy trial. He was, by every account, a competent and conscientious attorney who took his client's defense seriously, not because he was without moral conscience, but because he believed that the adversarial system required competent representation to function justly, and that a 14-year-old, however disturbing his behavior, deserved that representation. His closing argument was his most effective performance of the entire trial, and it was, paradoxically, made easier by the very completeness of the prosecution's evidence. Because his argument was not about the facts. It was about what the facts meant. Finch returned to the adolescent brain with renewed focus. He cited Roper, Miller, and Montgomery. He cited the American Psychological Association's amicus briefs in those cases. He spoke about what it meant, legally and morally, to impose adult culpability on a developing mind. He asked the jury to consider, if we accept that the teenage brain is constitutionally different, and the Supreme Court has accepted exactly that, then what does it mean when that brain, however disturbed, commits a terrible act? It means we have a system that is designed to hold 2 things simultaneously: accountability and the possibility of change. Ladies and gentlemen, throw away the first without the second, and you have not achieved justice. You have achieved only punishment. Finch attempted, carefully knowing the risks, to humanize Caleb. He described his client's childhood, the absent father, the instability. He noted that Dr. Shin's own report identified environmental factors that had likely amplified Caleb's underlying traits. He did not excuse what had happened. He said clearly, what he did was wrong. It was a terrible wrong that cannot be undone and should not be minimized. And then he said, but the question before you is not whether he is guilty. The evidence has established that. The question before you, the only question, is what kind of society you want to be and how you respond to it. Miriam Cole stood before the jury for 1 hour and 11 minutes. She did not use slides. She did not use notes. She began with Karen's tulips. She ended with Karen's journal entry, the one about sitting behind the chair in the dark, too afraid to open her eyes. She said, she was his mother. She sat in the dark, afraid of her own child, and in the morning she got up and made him breakfast. She loved him without defense right up to the end. And he repaid that love with 6 blows of a bat she had bought for him. She paused. The defense would like you to see a child in crisis. I would like you to see what the evidence actually shows. A person who planned, who researched, who executed, who concealed, who lied, and who, when caught, smirked. She turned briefly toward the defense table. Caleb met her gaze without expression. Convict him, she said. And sat down. The jury retired at 2:17 p.m. They deliberated for 9 hours and 33 minutes across 2 days. According to post-trial interviews, the deliberation was not contentious. The factual evidence was too complete for significant dispute. The 9 hours were spent primarily on 2 questions. The degree of the charge, first-degree murder, required proof of premeditation, which the defense had contested as inconsistent with the impulsivity of adolescent behavior, and the weight to give the journal. On the second day of deliberation at 11:47 a.m., the jury returned. Caleb Morrow was brought into courtroom 4. Judge Mercer entered from chambers. The foreperson, a retired schoolteacher named Margaret Hollis, stood and delivered the verdict in a clear, unhurried voice. Guilty of murder in the first degree. Caleb did not move. He did not change expression. He stood very still, as though he had been prepared for this, had incorporated it into his model of events. Karen Morrow's mother, Gloria, in the third row of the gallery, pressed both hands over her mouth and made a sound that no one who heard it would forget. The verdict was in. The smirk at the defense table, the research, the floorboard, the plastic bag, the gas station footage, the tulips, the journal, the chair against the bedroom door, all of it had been weighed by 12 strangers and found to constitute first-degree murder. Now only one question remained. And it was the question that Judge Catherine Mercer had been quietly preparing to answer since the day she read Dr. Shin's report and stood at her office window for a very long time. The sentencing hearing was scheduled for 30 days out. The legal community was paying attention. The 30 days between the verdict and the sentencing hearing were, for everyone involved, a different kind of waiting. For Gloria Morrow, it was the waiting of someone who had been promised something she couldn't quite trust yet. For Gerald Finch, it was frantic. He filed 4 pre-sentencing motions, each challenging a different aspect of the potential sentencing range, citing Miller v. Alabama's prohibition on mandatory life without parole for juvenile offenders. For Caleb Morrow, in his cell in the Essex County Correctional Center, he had been moved from juvenile detention following his conviction as an adult. It was the waiting of someone calculating probabilities. What none of the parties knew, what would not become public until the sentencing hearing itself, was that Judge Catherine Mercer had, 3 months before the verdict, commissioned a private legal brief from a research team at Rutgers Law School. The brief was titled, Therapeutic Jurisprudence and Indeterminate Sentencing in Cases of Juvenile Defendants Convicted as Adults, a Framework for Accountability Without Foreclosure. It was 47 pages long. It outlined a sentencing structure that had been used in modified forms in 4 other states but had never been applied in New Jersey. Its central proposal, a sentence that combined immediate incarceration with mandatory structured psychological treatment, regular judicially supervised review hearings, and a framework for potential sentence modification, not parole but reconsideration, based on measurable, documented psychological change over time. The sentencing hearing opened with victim impact statements. Gloria Morrow spoke first. She was 71 years old, and she had driven herself to the courthouse. She spoke for 12 minutes without notes. She described Karen as a child, her curiosity, her stubbornness, her kindness. She described the Sunday phone calls. She described the last time she had seen her daughter alive, Thanksgiving, 3 weeks before her death, when Karen had brought Caleb and they had eaten together and Caleb had been polite and quiet and Gloria had thought he seemed tired. She ended by addressing the judge directly, I am not here to ask for vengeance. I am here to ask for truth. I want it to be on the record in this room, that my daughter was a complete and irreplaceable person, and that she is gone. Diane Castillo's statement was shorter. She read from a paper, her voice steady until the last paragraph when it broke. She described the last text Karen had ever sent her, the Tuesday morning of the week before her death. Made Caleb pancakes. He said they were good. Small victories. She looked up from the paper. She was fighting for him every day. Every single day. That's who he killed. She folded the paper. She sat down. Caleb Morrow was given the opportunity to speak at sentencing. He had prepared a statement. He read it from a paper in a measured, even voice. He expressed regret, but the regret was structured in a way that Dr. Shin, present in the gallery, would later describe as the language of remorse without its substance. He said he understood the impact of his actions. He said he wished things had been different. He said he intended to use his time to improve himself. He did not say he was sorry. He did not say his mother's name. When he finished and sat down, Gloria Morrow in the gallery was looking at the wall above his head as though she had decided not to see him. Judge Mercer had the courtroom's complete and absolute attention as she gathered her papers and looked out at the room. She was 63 years old, with gray hair cut close and the posture of someone who had spent 30 years refusing to slump. She had presided over homicide sentencings before. She had sentenced men to life. She had sentenced men to decades. She had given speeches about justice that were quoted in legal journals. What she was about to say, what she had spent months preparing, was something she had never said before. The courtroom was so quiet that the gallery clock's ticking was audible from the front row. Judge Mercer opened a folder. She looked at Caleb Morrow for a long measured moment. He looked back without flinching. And then she began to speak, and what came out of her mouth in the next 22 minutes would be discussed in law schools, in courtrooms, in op-ed pages, and in the homes of people who had been following this case from the beginning for years to come. Judge Mercer began by addressing the law. She cited Miller v. Alabama, in which the Supreme Court held that mandatory life without parole for juvenile offenders violated the Eighth Amendment's prohibition on cruel and unusual punishment. She cited Montgomery v. Louisiana, which made Miller retroactive. She cited Graham v. Florida. She was not citing these cases to excuse Caleb Morrow. She was citing them to establish the framework within which any legally sound sentence had to operate, and to demonstrate that she had done the legal work, that what she was about to do was not impulsive or emotional but rigorously constructed. She then turned her full attention to the defendant. Caleb Morrow, she said. You are 15 years old. You are convicted of the first-degree murder of your mother, Karen Ann Morrow, who loved you more than you were capable of understanding or, I believe, of recognizing as real. The evidence in this case does not show a child who acted in crisis, or in fear, or in a moment of catastrophic impulse. It shows a child who planned, who researched, who executed, and who afterward, here in this courtroom, smirked. She paused. The silence was absolute. I'm not going to pretend that word doesn't mean something. It means something. I sentence you to 40 years in a New Jersey State Correctional Facility for the crime of murder in the first degree. The gallery breathed, some with relief, some with surprise, some with grief. But Judge Mercer was not finished. She continued, however. This sentence will be governed by a structured review framework that I am implementing pursuant to this court's authority under Miller, Montgomery, and the rehabilitative principles that govern all juvenile sentencing. Beginning at the 10-year mark and every 5 years thereafter, you will appear before this court, or its successor, for a mandatory review hearing. Those review hearings will not be parole hearings. They will be assessments. You will be evaluated by a court-appointed forensic psychologist. Not a psychologist you select, not one selected by your attorneys, but one selected by this court, using validated instruments for assessing psychological change, empathy development, and antisocial trait remission. You will be required to participate in mandatory therapeutic programming for the duration of your incarceration. If, at any review hearing, the evidence demonstrates genuine, documented, measurable psychological change, not performed change, not coached answers, not the language of remorse without its substance, this court retains the authority to consider sentence modification. If it does not, you will serve the full 40 years. Furthermore, Judge Mercer continued, I am requiring that the record of this sentencing, the full record including Dr. Shin's psychological assessment, the victim impact statements and this court's reasoning, be submitted to the New Jersey Supreme Court as a petition for the formal establishment of a structured review protocol for all future cases in which a juvenile under 16 is convicted as an adult of a violent felony. I am asking that court to do what this court alone cannot, to create a system. She looked up from her papers. Because what this case has shown me is that we do not currently have the right system. We have a binary. And the binary is not justice. In a moment that would be replayed and quoted extensively in the weeks that followed, Judge Mercer set down her papers entirely and spoke without notes. Karen Morrow sat behind a chair in her bedroom in the dark, afraid of her own child, and in the morning she got up and made him breakfast. That fact, that act of love in the presence of fear, is the moral center of this case for me. It is not lost on me that she was his mother and she never stopped being his mother, and that this court cannot be anything other than what the law allows it to be. But within what the law allows, I am going to ask that we do more than we have done before. For Karen. And for every parent who has ever sat in the dark and hoped. The gavel fell. The sound it made in courtroom 4, the flat, clean crack of authority meeting was something that everyone present would remember with unusual vividness for years afterward. Caleb Morrow was led from the room by 2 corrections officers. He did not look back. He did not smirk. For the first time in the entire proceeding, his face was, for a moment, simply the face of a boy. The smirk was gone. And in the 3rd row of the gallery, Gloria Morrow, 71 years old, pressed her hands together in her lap and looked at nothing in particular for a long time. The reaction to Judge Mercer's sentencing was immediate and layered. Legal scholars described the structured review framework as unprecedented in its specificity and its constitutional grounding. Juvenile justice advocates, who had initially opposed the adult transfer, expressed cautious support for the review mechanism, noting that it preserved a pathway for rehabilitation without eliminating accountability. Victims' rights organizations were divided. Some praised the 40-year term, others questioned whether any review mechanism was appropriate given the nature of the crime. The New Jersey Attorney General's office issued a statement expressing support for the sentencing framework and pledging to cooperate with Judge Mercer's petition to the Supreme Court. Judge Mercer's petition, formally filed within 30 days of sentencing as promised, was a 49-page document that laid out a proposed framework for structured sentencing review in juvenile as adult cases. It included a review of comparative law from Montana, Connecticut, Louisiana, and California, where similar mechanisms had been developed in various forms. It cited the research literature on adolescent brain development, on psychopathy treatment outcomes, on the risk factors for recidivism, and on the conditions under which genuine psychological change had been documented in high-CU trade offenders. It was, in the opinion of Professor Elaine Rosenberg of Rutgers Law, the most thorough piece of informal judicial advocacy ever submitted to a state Supreme Court by a sitting trial judge. The court agreed to review it within 4 months. Dr. Patricia Shen, who had conducted the psychological evaluation, gave a single public interview in the weeks following sentencing, to a legal publication, not a general news outlet. She said that she had been skeptical that Judge Mercer's framework would survive legal scrutiny. After reading the sentencing document in full, she revised that assessment. She said, "What the judge has done is ask the right question, which is, what does accountability look like when we are honest about what we do and don't know about an adolescent mind, even a dangerous one? I don't have the answer. I'm not sure anyone does. But she's asked the question in a way that the law can engage with. That's more than I expected." Karen Morrow's mother and sister declined all media requests following the sentencing. Their attorney released a single statement on their behalf. "We are grateful for the thorough and careful work of the prosecution, the investigators, and the court. We ask for privacy as we grieve the irreplaceable person we have lost." Karen Morrow was a nurse, a friend, a daughter, and a mother. She was afraid in the dark and she got up in the morning anyway. "We will carry that with us." The statement was widely shared. It was the only public statement the family ever made. Caleb Morrow was transferred to a New Jersey State Correctional Facility 42 days after sentencing. He was placed in a specialized unit for young adult offenders, where he was enrolled in the mandatory therapeutic programming as ordered by the court. His first psychological review, conducted by the court-appointed evaluator, not Dr. Shin, occurred at the 1-year mark as required by the framework. The results of that review were sealed. The next review was scheduled for 5 years out. Whether what happens inside those sealed sessions constitutes change, genuine change documented and measurable, remained at the time of this writing unknown. That was, in some sense, the point. 14 months after Judge Mercer submitted her petition, the New Jersey Supreme Court issued a ruling in the matter. By a vote of 5-2, the court formally endorsed the structured review framework and ordered its adoption as standard procedure in all future juvenile as adult murder cases in the state where the defendant was under 16 at the time of the offense. The dissent, written by Associate Justice Harlan Wells, argued that the framework placed too much discretionary power in individual judges. The majority opinion, written by Chief Justice Loretta Francis, began with a line that was cited in law review articles across the country. "Justice that forecloses the possibility of truth is not justice. It is administration." The tulips on Fenwick Lane were planted again that April, by Eleanor Vance, alone, who had made it a private tradition. She planted them in the same spot Karen had always planted them. She did not have a particular reason she could articulate. She just felt it was right. The house had new tenants now, a young couple who didn't know the history, who had repainted the rooms and put up different curtains. The street was quiet. The kind of street where nothing like this was supposed to happen. It still looked that way from the outside. Justice rarely looks the way we imagine it will when we are in the middle of wanting it. In crime stories, justice is often presented as a clean transaction. Crime committed, crime solved, punishment delivered, ledger balanced. The Caleb Morrow case resisted that architecture at every turn. The crime was horrific in its planning and its execution. The evidence was overwhelming. The conviction was sound. The sentence was, by legal standards, significant. And yet the family did not feel that the ledger was balanced, because ledgers do not account for tulips planted alone, for Sunday phone calls that will never happen again, for a small spiral notebook with a floral cover that will sit in an evidence archive for decades. Beat 2. What Karen left. What Karen Morrow left behind, beyond her death, beyond her role as victim in a legal proceeding, was a body of evidence of a different kind. The text messages to Diane about fighting for her son. The tulips replanted every spring. The lunch packed on the last morning she was alive. The journal entry written in fear that ended, "He's my son." These were not pieces of a case. They were pieces of a person. And the fact that they had to be introduced into a courtroom to serve the function of evidence was itself a kind of injustice. Not legal but existential. She had been a full human being, reduced to exhibits and timeline entries, so that a jury could understand what had been lost. Beat 3. What Caleb left. Caleb Morrow, at the time of this narrative, is serving his sentence. He is participating in mandatory therapeutic programming. He is being evaluated on a schedule. Whether any of that evaluation will, 10 years from now or 20, produce a person who is genuinely different from the one who stood in courtroom 4 and smirked, that question cannot yet be answered. What can be said is that the question is being asked. That the framework Judge Mercer created demands that it be asked, with evidence, by qualified professionals on a schedule forever, for as long as the sentence runs. Whether that constitutes hope is a matter of perspective. Whether it constitutes accountability is clearer. Beat 4. Dr. Shin's Coda. In a follow-up journal article published 18 months after the trial, Dr. Patricia Shin wrote about what she called the epistemological problem of the high CU adolescent in the justice system. She noted that the system is built on the assumption that moral accountability is self-evident, that people know what they have done and feel its weight. She argued that cases like Caleb Morrow's exposed a flaw in that assumption. When the architecture of guilt and remorse is absent, the system does not know what to do. It can punish, but it cannot be certain it has reached the person it is punishing. She ended the article, "What Judge Mercer created is not a solution. It is a better question. In law, as in medicine, a better question is sometimes the most we can achieve. It is still worth achieving." Beat 5. Judge Mercer's legacy. Judge Catherine Mercer retired from the bench 4 years after the Morrow case. At her retirement ceremony, a colleague described her in 3 words: precise, courageous, and patient. Her sentencing framework had, by the time of her retirement, been applied in 6 additional cases in New Jersey and had been cited by courts in 3 other states as a model for structured review. She was invited to speak at a symposium on juvenile justice reform at Yale Law School. She declined. She sent a written statement that ended, "I made one decision in one courtroom for one case. The system will decide if it was the right one. That is how it is supposed to work." Beat 6. The final question. This story does not end cleanly. It does not end with the ledger balanced, because that ledger will never balance. It ends with a boy in a cell, undergoing evaluation, his future contingent on measurements of interiority that are still imperfectly understood. It ends with a family in quiet grief that does not go away. It ends with tulips planted by a neighbor on a quiet street, for reasons she can't quite articulate. And it ends with a judge who looked at a smirking boy and decided, against every simpler option, to ask the harder question. Was justice served? Every viewer, every reader, every person who followed this case has to answer that for themselves. The answer they give says something about who they are, and what kind of justice they believe is possible. Beat 7. Final echo, poetic justice close plus seat. Karen Morrow sat in the dark, afraid, and in the morning she got up anyway. That act, quiet, unglamorous, unremarkable, is the moral center of everything that followed. The investigation, the trial, the journal, the gavel, the 40 years, the tulips. She got up anyway. And because she had written it down, because Yvonne had found the notebook, because Detective Hurst had read it twice, because Miriam Cole had read it aloud in a courtroom, The world knew what she had done. Not as a victim. As a person. The smirk is gone. The judgment stands. And in the back of an evidence archive, behind a numbered shelf, a spiral notebook with a floral cover holds the handwriting of a woman who loved her son all the way to the end, and who, in loving him that completely, left behind the truth that finally brought him to justice. If you think justice was served, make sure others see this story too. Share it. Because the stories we tell about accountability shape the world we live in.